the group.
Thank you, Chair.
Thank you. Carol. Timothy, please.
Thanks very much. Just picking up on something you said there, Andrew. Information not being shared with the applicant. What would that look like, or what could that be?
I think that this is very much in the early stages of thinking through what it would look like to be able to access information that the redress service will need to process an application, because there are powers there to compel. So there's potential that information could be accessed by a truth recovery service, but it's a separate process for individuals to access that information. I'm getting that correct, I think.
I can probably, if it's helpful, send a case study across to help to illustrate it, where there's a lot of back and forward between an institution and evidence not found, and then maybe we're able to supplement with evidence of a birth certificate, or find out that somebody was in a workhouse, for example, and then go back to the institution and maybe a bit more information is uncovered, but we can supplement that and help to validate.
Why wouldn't that be shared with the applicant?
Good question.
That's a concern I have, that you have raised that concern. So we're looking at a system where we're going to have redress payment for anybody that has been in an institution. The next stage of this will be somebody that has faced, there will be a payment based on their experience of what they've faced. If you're coming in front of us today and saying there'll be information that would be shared with the applicant, essentially that could put in jeopardy their phase 2 payment in this.
I think we're at the very early stages of working through what those problems look like, and what the solutions to them will be. So I don't want to go too far in terms of saying that is an issue that can't be resolved, but it's part of the early discussions around how information will flow from the various sources to both the redress service and to an applicant.
There's obviously a conversation that has taken place that has put that doubt in your head, and that's something that concerns me greatly. If it's somebody's own personal information, they should be entitled to see that, and there should be no barriers put in their way that would rule them out of getting a phase 2 application or evidence to support their phase 2 application further down the line.
So an individual's right to access their information, and their information is through specific processes, and it involves, in some cases, redaction of files, social workers. You know, there's a process there that has to happen. Whether there's any other routes that information can be accessed is something that has to be worked through, I think, over the next as we prepare and design these processes for the scheme.
Moving on then to some of the questions that I had. VSS was set up in 2012 by the Executive Office, essentially to deliver for victims and survivors of the troubles or the conflict. What learning has there been from the 2006 order, which classifies a victim as a survivor of a conflict-related incident? Where I'm going with that is there's a realisation that you couldn't have somebody that was hurt by their own bomb in the same room as somebody that lost a son to a bomb.
Obviously, we're here to talk about the bill.
Yeah, and that's where I'm heading. We talk about a trauma-informed approach, and what we have heard in the past is where you have had birth mothers and adoptees put in the same room, which has created tensions before we've got to this stage, where we've heard about a client journey, and I'm really wanting to understand, has there been lessons learned? Like, this isn't the first rodeo for VSS. This is something that you've been through, where I'm talking about the bomber and the person that has been injured by the bomb. But we've repeated that and putting birth mothers and adoptees in the same room. So what assurance have we that when we get out of this, the other side, that this client journey will actually be a trauma-informed approach, and we're not going to rehearse and repeat the problems that we've established and we've seen through to get here, which has caused a lot of pain.
So the client journey and the applicant journey are primarily around that individual's route through to individual-based support. There are times when individuals will come together, either in group-based activity, which Sandra might say something about because we have led on a lot of that, or in forums such as the consultative forum or the advisory panel when it is formed, if it is formed, because I think it is important that there is that wide range of voices.
There needs to be an
structure
understanding of the tensions.
Yes, absolutely, and I think that's where the support and services need to wrap around. And as I said, all of the sort of support and services that we've put in place since 2021 in this space have been to wrap around the various activities that have been happening at those times, be it the consultative forum and the early stages of that, and that is difficult, of course, and VSS have been there throughout all of that period, all the way through to the independent panel's work, through your committee's work, and as we go forward into other services around the inquiry and the redress scheme. There are times when groups work together. Sandra, you've facilitated some of that, I think, already, so there's something you can say about group work.
I mean, ultimately I think there has to be care and support, but it's looking at where the individual is at and assessing their needs and working through with them in relation to a very clear plan of care. And nobody will be put into a position whereby the workers they will be working with them as they present and the issues that they have. But I think that for examples around consultative forum or the various initiatives that if people are happy to come to give I think there's going to be huge learning, because there can be many assumptions from birth mothers about the adult adoptees or adult adoptees about birth mothers, and I think if people are prepared to come into that and feel that they can share their experiences and their voice will be respected, then that can be a very worthwhile process. I think the more that people's voices are heard, because people have been silenced, they've been marginalised, they've been excluded. In some cases, the silence even permeates right down through their family. There's huge work, I think, in relation to supporting people and to give them the best in terms of the work that Adopt and I do in relation to tracing and DNA. If you don't have that, to have that and to have control over that is really important. But the big thing, I think, is about ensuring youth services where people are in control and they make the choices. It's not something that I may think is good for somebody or Andrew may think is good for somebody. It's what the person and they make the choice around how they want to contribute and in what way they want to be heard.
Next area that I want to ask some questions on is the reach and promotion. So looking at the victims' pension and drawing comparisons from it, there's only 1,000 people or less than 1,000 people in GB have availed of that. So we have a redress scheme. How can we make sure we have utilised and getting that information out there that people know, where in the past, right, compare it to the victim scheme where there's an under uptake. You think the amount of people that have left Northern Ireland that have came here maybe served for years and haven't looked for the victim's pension. How can we best utilise our resources to ensure we're getting as many people, yes, in Northern Ireland, the South, but also in GB, because that's obviously a problem in the past where we haven't been able to reach that audience.
I think one of the things that would be useful there would be an understanding of responsibility for communication around the scheme and for advertising and promotion around the scheme. There is obviously something in the bill around advertising of the scheme opening date, and that has to be done. I don't think there's anything else around who will take overall responsibility for promoting the scheme or promoting engagement with the inquiry. We will all play our part in that. But it may well be useful that we have a better understanding of who takes the lead and where the budget then would come from to do that work. We can all do targeted promotion through our own channels. There's quite a wide reach across, I guess, social media and other platforms that we would have between the three organisations. And we'll obviously do that. We'll obviously also try and target any information that we can get to places where we know that those who would be eligible may be. But I take the point and I agree that it would be useful to have a sort of a combined approach on that.
In Matters Arising, we had the slides from the Victims and Survivors Forum, the members' views. So out of that, it was sent out to 236 victims, survivors, only 54 responses. I just have a concern that we are not reaching the people we need to reach. And that's something that I want to put strongly on record of something we need to have an associated budget and a clear pathway of how we're going to get to these people. So looking at the redress and the £10,000 payment, so that was set 2015 essentially, and this is something I've explored with the groups that were in giving evidence last week, and there's a lot of victims that money will never replace or compensate for the experience they have. They don't care about the money, but there is some people that certainly that means something to them, that they're getting their recognition. So £10,000 in 2015, essentially with inflation, looks somewhere like £14,000 now. Is that a figure that better reflects the recognition? Is that something? What's the feedback on that to yourself?
I think there's a lot of different views in that, and we saw that with the consultation in terms of settling on what an appropriate figure would be, and again the same points that you've made about no amount or no figure will ever be a compensation. Other schemes have approached this in different ways. I think the 10,000 is often linked back to the figure that was maybe the entry level for payments under HIA, which was some time ago, but that did stay as the payment throughout the 5 years of the scheme. So if applying at the end of the scheme and the beginning of the scheme was the same amount, even though there was a period of inflation and cost of living between those two dates. On other schemes like the Troubles Permanent Disablement Payment Scheme,